State versus Carter, but in a different time and cultural setting. Carter held that ordinarily the use of a deadly weapon gives rise to an inference of malice and an unlawful killing, but the state keeps the burden of proving an unlawful killing. And where the state's evidence shows that a killing was justified and therefore lawful, and this evidence is not contradicted or shown false, the state is bound. This was not the kind of self-defense case where there were several witnesses giving conflicting stories about who started it, who pulled a weapon, who responded how. Those situations require a jury. This case had one version. Dominique shot Michael to stop him from beating Sierra. I'd like to go through Carter and just look at the facts and compare them and show you how similar they are, even though the settings are different in these two cases. First of all, in Carter, the assault was by a father against his wife. It was a domestic violence assault. He used his fists and he had a wine bottle that he hit her with. In this case, domestic violence, Michael was beating his girlfriend Sierra. He beat her with his fist and with a beer bottle, which he cracked over her head while she was driving down the interstate.
I'm going to jump in and ask a quick question. I know it's not about Carter, but it's about the videotape that we've got. How do we judge that videotape? So we've got some, the witnesses were watching it and they were saying what they saw go on, but the jury makes its own determination and conclusions from that. Do we just use our own opinion as to what we see on that videotape to determine whether it's sufficient? Because it may either contradict how you argue it or it may not.
Right. I think it's a piece of evidence and the court can draw reasonable inferences from that evidence, just like the jury could. And maybe there's a range of reasonable inferences, but they have to be reasonable. And some of the state's arguments, which I'll get to later, are highly speculative. And for example, saying that Dominique just standing still means that he's unconcerned. And you cannot infer that from someone standing still. You don't know what's in his head. And so I think you have to look at the piece of evidence in its full context, see what you're able to see, and draw reasonable inferences from it. So the assaults were very similar. In both cases, the assailant never withdrew. The father kept coming. He did take breaks. The daughter and the mother were able to get out of the house. And then he came stumbling out and came after them again. And then he took a break and went looking for another implement to hit someone with. But he started back again and he never withdrew. The same is true of Michael. He started this in the car when he said, "I'm going to kill you," and hit Sierra over the head with a beer bottle while she was driving. And he never stopped. He took short breaks, but he never calmed down and he started right back up again. And most importantly, he never withdrew. He didn't say, "Okay, I'm good now. I'm going to stop beating you." Instead, he said, "Get out of my way. I can do whatever I want" to Sierra. He said nothing about stopping. He just continued. The force used by the defendants in the cases were both deadly force. The daughter in Carter found a bumper jack, a big heavy item, I assume, and beat him over the head with it for a long time until he collapsed, multiple blows. And in this case, Dominique used deadly force. He fired his gun 2 times in quick succession. In both cases, the defendants left the victim lying there. The daughter in Carter took her mother to the hospital and left their father laying on the ground and told their younger son to get him some help. And in our case, they loaded Michael into the car. They drove him and said they were going to get him medical help. And I know the state is complaining that they didn't go straight to the hospital or they could have made a better decision, but they did make an attempt. And when he stopped breathing, they stopped the car and Sierra called 911. And I believe those two are fairly equivalent. And then the final comparison is that in Carter, the daughter turned herself into the sheriff a few hours later. And she did that by going to his house, his personal house at 9 p.m. and knocking on his door. In our case, Dominique turned himself in the next day and he went to the police department downtown and said, "I shot my cousin." So I think on all of those important points of comparison, these cases are square with each other. What defensive force does not require is that the defendant's behavior is morally perfect. The law recognizes that people in these situations are fearful. They don't have time to give a lot of thought to their actions. They're shocked, they're stressed, they're in the heat of the moment, they're panicked, and they don't have to do everything exactly right. And a lot of the state's argument.
Sorry, it's so difficult to break in on video. I apologize for interrupting.
It's fine.
Can you talk to me a little bit about this inference of malice that we've got with this intentional killing with a deadly weapon, and how that disappears, if it disappears completely or if it doesn't disappear at all? Obviously, you and the state disagree on that point.
So, I mean, what Carter said is ordinarily, yes, there's an inference from that, but the state always keeps the burden of proving that it was not an unlawful, whatever that is, the killing was unlawful. And in this case, you know, where there are two versions, and most of the cases do have two versions. You know, there's a case at a NC State football tailgating thing, and there's one group of guys who testify, well, this is what happened, and there's another group of guys who said, no, that he didn't start it, this person started it, and he didn't react that way. That is not the case here. The whole story told by the state is Michael started it in the car. Michael wouldn't stop. Michael was beating her viciously. There was no disagreement about who the aggressor was, who was the stronger party. I mean, Sierra, she gave a shove and she was angry, but she was not a match for Michael, clearly, because he had her in the car and nobody could stop him. In fact, they were pulling out his hair and he wouldn't stop. So I think when the facts only point in one direction, that is when the state has failed in its burden to show a different story. So I think in that case, the inference is overcome, and it's the state's burden to beat it. And Carter says when the state's evidence only shows one thing, they're bound by their evidence, and that's the end of the story.
And so you use the words inference, but it seemed we're talking about a presumption of malice. In this case, does that presumption merely turn back into an inference that the jury could consider?
And I think the presumption is gone when the state doesn't put on evidence of an unlawful killing. When the story their witnesses tell, and when the videotape is consistent with the story their witnesses tell on the major points, then the presumption is gone. Presumptions can be overcome. I'd like to talk about a few of the state's arguments about the facts. So one is, this was Sierra's fault. She shouldn't have bought alcohol. She shouldn't have gone out with Michael. She shouldn't have made him mad. This is a domestic violence case, and those arguments are totally inappropriate. Sierra has a right to defend herself, and nothing she did excuses Michael's brutal assaults on her. Sierra was not the aggressor. The initial aggressor, all the testimony showed that was Michael. He maintains this aggressor status unless he clearly withdraws, and no testimony showed that he ever clearly withdrew. The fact that Sierra pushed him after they had to stop the car the second time when he still wouldn't stop attacking her while she was driving, that's a minor shove. That is not two equal people, and she's restarting something that he stopped. If you watch the video, she pulls over abruptly. Everybody jumps out of the car. The affray is still happening. And as soon as she does that, he has her down in the back of the car, and they can't stop him. Like I said, they pulled some of his hair out, or, you know, extensions, and not out of his scalp. But, you know, Dominique was doing what he could, and Tyler was doing what she could to stop him, and he refused. And in fact, he turned around and said, "Get your woman off me. I can do what I want to mine."
All right, me again.
Yeah.
So if you watch that video and there's this 8-second delay, there's nothing going on in the car. The deceased is standing in front of the doorway of the car. The defendant is in the rear. If we were determined that at that point that he had in fact withdrawn, we've got an 8-second period here. How does that change your argument if he's withdrawn? Is there an aggressor instruction then that is correct as to defendant in this case? And do we start anew?
I don't watch the video the way you just described. I don't see Michael.
If you were determined that pause, there's a pause, correct? In the action.
I wouldn't call it an 8-second pause. I think Michael, I wouldn't call it a pause in the attack at all. I mean, he didn't withdraw. He didn't stand up and say, you know what, I'm done. You know,
but he doesn't have to say anything, correct? He doesn't have to announce to the world.
To clearly withdraw, all he did was stand up for a moment. I mean, 8 seconds is how long. I mean, 8 seconds under the case law does not constitute a withdrawal. If you look at the Coley case, that's a guy in a wheelchair, and the other person accused him of being a snitch or something, and he beats him up at someone's house, knocks him out of his wheelchair. He's able to get home, gets himself in the house, and then the guy comes back and comes at him again. And then the guy leaves again, and then some more time passes, way more than 8 seconds. And the guy comes back a third time, and Coley shoots him dead. And that is not a withdrawal. I mean,
okay. So hypothetically, if this is a withdrawal, it's just let's put aside that argument. Okay, if this is a withdrawal, where does that put us with regard to the aggressor instruction and the self-defense?
Well, and that depends on which version you're using, right? Because under the statute, the aggressor rules are different, and you can look at Holloman and all of that circle. But in this case, Mr. Williams didn't ask for the aggressor, and now we might be getting to part 2. But I think under the common law, I'm having trouble fitting your scenario into what actually happened, because if the whole situation were over and then Dominique suddenly shot Michael, that would make Dominique the aggressor. But I just don't see that fitting into the facts.
Okay.
Yeah. One of the other arguments the state makes is about the behavior of the defendant and the 2 women afterwards, and saying, well, that is enough to prove that their story is completely false. And I think that is also an unfair inference. If you look at the whole situation and who these people are, compared to Carter, where you've got this daughter, she's not in fear of the police, right? She's living in Mayberry in 1960, and she goes over and knocks on the sheriff's door at night. That is a very different situation than Dominique Williams and Sierra. Sierra, the last time she called the police when Michael caused her to run off the road, she ended up getting arrested. And Dominique, in the middle of all of this, think about the situation he's in and the emotions he's having, right? The adrenaline is pumping. They've tried to stop Michael. He shoves people off. He says, I'm not going to stop. I'm going to keep beating her as long as I want to. He maybe fired warning shots in the air. They're trying to, all 3 of them, get him to stop, and he can't. Think about the emotions of Dominique Williams. He's angry. He's afraid. He fires the gun, and then he's shot his best friend. He doesn't know what's going to happen to Michael. He doesn't know what's going to happen to him. I think it is unfair to say the fact that they put him in the car and made up a story to try and stay out of trouble for all 3 of them is enough to outweigh all of the evidence which shows that there's only one reason he shot Sierra. What would be the other reason? The state presented nothing. Why do you shoot your best friend in the middle of this double date, except for the events that occurred, which that he was attacking Sierra and put all of them in danger when they were driving down the road? So I think
Can we jump over, just perhaps it's going to be brief, to the instruction on self-defense and the fact that the trial court wouldn't give it because of Crump. And we know that Crump came down and didn't actually address it, correct? But we've got Macklemore right in front of the Supreme Court. Don't we have to wait for that?
I mean, we thought we had to wait for Crump, and they would decide, and they didn't. But barring that, and there's not just Macklemore. There's 2 other cases now. There's the one that's leaks that's getting argued the same day. I mean, I don't think you have to wait for that, but I don't know why you wouldn't, because
Okay.
unless they just somehow don't decide it, but that's really the only issue in Macklemore. So,
Okay.
um, eh, yeah, I think,
That makes sense. It doesn't
and
make sense to talk about that
yeah,
right now.
well, I mean, we can talk about it, and there, I have some points to make, but I feel like, for this court to go out on a limb and struggle with it, and what are we going to decide when the Supreme Court is probably going to go with it. And you can also look at, I mean, I watched the Crump argument from a year ago to try and sort of understand where I thought the Supreme Court was going. There's some different judges now, so who knows, but I would, if it were me, I would wait and see what they did. I don't think you have to, because there's no binding ruling from them about Crump.
But although at this point we're bound by Crump because the Supreme Court didn't address it, right? And it's a 2-to-1 case.
Well, I disagree with that. I think the rule is not clear. I don't know of a case that says exactly how the Court of Appeals should treat it when the Supreme Court does what it did. But civil penalty, the exact language, is a panel is bound by a decision of a prior panel unless it has been overturned by a higher court. And I think there's room to argue that Crump was overturned. I mean, the ultimate ruling in Crump was reversed. They didn't say reversed in part and affirmed in part. They didn't say discretionary review and providently granted. So I think it's fuzzy, and I wouldn't say that you're bound by it. I think that when they ordered a new trial, they didn't have to decide the second issue. I don't think that's the same as leaving it alone. And maybe you know better than me. I don't see any rules or case law that says for sure.
I think that's a tough argument to make, but I don't think it's been overruled. It just wasn't reached. But that really doesn't matter, right? We've got Macklemore there that actually answers more questions than we've.
It answers more questions than Crump does, because
Right.
There were problems with Crump that don't exist here. And one other piece about Crump is that they argued this at trial that for Dominique Williams, he pled guilty to possession of firearm by a felon, but that evidence was never put in front of the jury. And that makes this an unusual circumstance, but that could take it out of the Crump scenario, because the jury should, if they don't have the evidence, whereas in Crump, the jury did have the evidence. That makes a distinction.
Can you address the state's argument that was invited error, or that they basically participated in that because of the plea?
They talked about that at the trial, and what I recall is that once that became confusing, that's a standard practice, right? Is to plead to possession of a firearm before trial, because you don't want the evidence of the felon to be in front of the jury. And that's been a standard practice for years. And then all of a sudden, all this new, what are we going to do with Crump? And Crump, at that point, Crump was, I think it hadn't been decided at the time of this trial. So everybody was in, it's hard to call it invited error when nobody knows what the law is yet, I think. And the counsel tried to raise ineffective assistance against themselves. We never would have advised him of that if we had known that this is the interpretation of the law that's unclear that the trial court is going to take. I mean, they went around and around about this. You probably haven't read the entire trial transcript, but there are many points before they finally come to the conclusion of how the instruction is going to go that they're going in circles. So I don't think it's invited error. I think that would have to be a more clear case where the law has been, fully decided. And obviously here it hasn't. The statute has been around a long time, but there are many, many questions that remain.
If we think Crump is controlling, then are there other grounds on which you can, even if we say we have to follow Crump, your client still prevail in this case?
Yes, Crump.
So I assume you're not saying just hold the case in abeyance no matter what we think to see what the Supreme Court does.
Well, clearly the sufficiency evidence takes it out of Crump and any other issue, but also, like I just said, that the possession of firearm by felon in our case wasn't before the jury, so that's one distinction. Also in Crump, they sought the statutory benefit of the stand your ground statutes. They were trying to get those favorable presumptions. In this case, they didn't want that. They wanted to go under the straight common law. And Crump had some dicta about common law. You know, it's now gone entirely. And now that McLemore then took that and made a ruling out of it, and McLemore will address whether the common law still exists, regardless of what happens if you're trying to seek relief under the statutes. But I think this court could say Crump did not, was not binding on its decision about the common law still applying. And there's plenty of support for that. The Coley case from 2020, the Supreme Court said, in North Carolina, the right to use deadly force to defend oneself is provided both by statute and case law. That's a direct quote from the Supreme Court. You can follow that. That was not the exact holding of it. You know, that was a sort of introductory remark, and then they went on to analyze their case. But that's a statement from the North Carolina Supreme Court. And I think this court could take that and say the common law still exists, and it wasn't given here. There are plenty of other cases where the Supreme Court has not explicitly ruled, but assumed that the common law still existed. Those are in the brief. Greenfield, Tyler Greenfield is one. Harvey, Lee, and Bass and Mercer, you know, all of these cases that involve self-defense, they've talked about the common law as if it still, you know, should be instructed on. And then sometimes the presumptions and sometimes not, depending on the various circumstances. So I think there's plenty of room for this court to go ahead and decide on the common law. And I think there's very strong reason to believe that's what the Supreme Court is going to do. I mean, McLemore was an unpublished and unanimous opinion, and the reason that they sought review was this exact question, and the court took it. So that's at least one indication. And then probably the argument next week will provide some more indication of where they're going to go.
Ms. Vandenberg, I just want to, you're into your 10 minutes. You wanted to reserve for rebuttal. I just want to point that out. So.
Okay, thank you. I will save the rest of my time.
All right, Ms. Babb.
Good morning, and may it please the court. I'm Mary Carla Babb with the North Carolina Department of Justice, here on behalf of the state. Your Honors, in this case, there was sufficient evidence to support defendant's second-degree murder conviction and no reversible error in the jury instructions, and therefore the state asks that you affirm. Turning first to defendant's argument about sufficiency of the evidence, I want to preliminarily say that in this particular case, because defendant wasn't entitled to an instruction on defense of other, the state didn't have to prove that he did not act in defense of others, so defendant's argument is wholly meritless. Sufficiency of the evidence is a completely different argument than the error in the jury instructions. Even if this court were to conclude that there was an error in the jury instructions, that he should have received it, that would mean there was insufficient evidence to convict him. That being said, there was absolutely insufficient evidence here, and you know, just sort of where defendant. Where the error in defendant's arguments are pretty obvious. Sufficiency of the evidence is you construe the evidence in the light most favorable to the state. The state is entitled to every reasonable inference, and it's clear from defendant's argument that the way the defendant is seeing this evidence in this case is construing in the light most favorable to the defendant. To say that afterwards defendant was stressed, that he was in shock, those are inferences in the light most favorable to the defendant. In the light most favorable to the state, it's that defendant didn't care about Sierra, that he just walked away, and to say that there was no motive, that the only motive here, first of all, you don't have to have motive for second-degree murder, but the motive here, in the light most favorable to the state, was defendant was disgusted with his cousin's activity. We know from the testimony of Sierra and Tyler that in the car he had said, "You're always doing this." A weekend before the defendant intervened, according to the women's testimony, he intervened and the victim pulled a gun on defendant at that point. And they had all been drinking. There's no question. Defendant was drinking a lot. Tequila, beer, drinking at shooters. And so his judgment was impaired, and he was absolutely disgusted by his cousin. He was so tired of the way he caused all these problems. And so to say that there's no other reasonable way to view this other than defending Sierra is absolutely incorrect. So far as the Carter case, this is distinguishable from Carter in several ways. Concerning the basic facts of Carter, Carter, just sort of, let me back up. Carter is a very, very narrow set of circumstances. But concerning the basic facts, in Carter, when the defendant takes the bumper jack or car jack and beats the father, he is headed towards the mother at that very moment. He is headed to her to continue to beat her with the wine bottle. In this particular case, when defendant shoots Michael when he emerges from the car, there's no movement towards Sierra. You have to have a belief that there's an imminent threat to Sierra, and that's just not shown on the video at all. He does not have that belief. So that's a big factual distinction, but the circumstances are wholly distinguishable. Carter, again, a very narrow set of circumstances. And when the court says in Carter, we know, clarifying that the court clarified after Carter, the defendant's statement and then a statement that's not contradicted by other evidence. Contradicted by other evidence doesn't mean directly contradicted. It means any evidence that sheds different light on the defendant's statement. And here you have the statement, you have the testimony of the two women as presented by the state. Their testimony was inconsistent. There were certain points of their testimony that was inconsistent with each other. Sierra's testimony was inconsistent with her prior statement, a prior statement by which she at first twice told the police the same story that defendant made up about the drive-by shooting, the Challenger coming by and shooting Michael. And Sierra even embellished that, saying, she tried to get out of the way and she stopped the car. So, and even when she gave a version of events that was more like her testimony, there were still some inconsistencies. For example, in her testimony, she says that Michael pushes her and she pushes her, she falls into the car. She doesn't mention it. She's not very specific about that in her testimony. She says they somehow ended up in the car. There's no mention at all in her prior statement about a beer bottle. Her testimony in that regard was inconsistent with the physical evidence, which was that there was no beer bottle in the car. There was no beer bottle either at the scene of where the shooting happened or in High Point, where defendant left Sierra and Michael on the side of the road. And we do have the video. In the video, it is clear, and really the only inference drawn from the video is that defendant did not have a belief that Sierra, when she was in the car, was under an immediate threat of harm. His actions do not reflect that.
On the video. I just want to ask a different question about the video. If this court were to determine that video shows that the defendant in this case at no time was the aggressor, then the aggressor doctrine, having given that instruction, seems to be error. Is there any way that it's not prejudicial error?
Yes, Your Honor. It's not prejudicial error because there was overwhelming evidence that defendant did not have the belief from the video, that he didn't have the belief. He has to have a belief that Sierra was under immediate harm, as she's about to suffer it. That can't be, the definitions can't be guarded against by calling police or the assistance of others. And it's very clear in the video. It's overwhelming evidence. The aggressor is in itself a type of fault disqualifier, if you will, for self-defense. So even if defendant wasn't the aggressor, if he didn't have that belief, he still is disqualified. He still cannot assert the defense of other. And so with the overwhelming evidence from that video that he had no, his own actions on that video showed he didn't have that level of belief that harm was to immediately fall on Sierra. overwhelming evidence, any error in the jury instructions, including not giving or not giving a full instruction for first and second degree murder and for the manslaughter instruction, those errors would not be prejudicial. And it
Can you
sounds
go over for me one more time? What is the overwhelming evidence that he did not have belief?
I'm sorry, Your Honor, I didn't mean to talk over you. In that video, if you look in that video, so Sierra drives up to TDR Motorsports, a car lot. Everybody emerges from the car. Tyler comes around the car to where Sierra and Michael emerge from the car. Sierra, you can see that Sierra pushes Michael. They go out of view. You see Tyler bend down, and she's sort of bent down at the car. According to her testimony, she's there trying to get Michael out of the car. Defendant is on the other side of the car. He comes around to the side where Tyler is, and at some point he sort of pulls her away from what she is doing, which according to her was trying to get Michael out of the car and get him off of Sierra. So defendant actually pulls her away from doing that. At some point he does bend down where she is, but as she continues to, on that side of the car, bend down and what she says, pull Michael out of the car and then go to the other side of the car, defendant walks, as she's vigorously trying to do this, defendant walks to the back of the car. He then gets closer to the bumper of the car. You can kind of see him with his hands at his waist, and then you see sort of a for lack of a better term, a sort of puddle form below him. It appears that perhaps he's urinating on the car. And so he's taking all this time when supposedly he believes that Sierra is going to get killed in the car. And then he walks back to the right rear quarter panel, and he stays there again while Tyler is moving back and forth trying to get Michael out of the car, according to her testimony. Michael emerges from the car. There's no indication that he's going to move back towards Sierra. Defendant walks around the car and shoots him in his chest, point blank. Shoots him 2 or 3 times, and he sustains 2 gunshot wounds to his chest. And so
why isn't it a reasonable inference that what is going on there is a man struggling to come to grips with the reality that he's going to have to use deadly force on a dear friend to prevent harm to someone else? There's nothing else he can do except
a man who's trying to save someone else would not be just walking around the car, taking time to stand at the car, appear to urinate on the car. He would be in there helping to try to get the guy. That's not a reasonable inference from this particular evidence. He would be helping to try to get him out so that he wouldn't have to shoot him.
If I can jump in, I'm sorry. So, when we're looking at sufficiency of evidence, obviously we look at the evidence in the light most favorable to the state. But when we're looking at instructions, we do that for self-defense. We do have to look at the evidence in the light most favorable to the defendant. Isn't that correct?
Yes, Your Honor. Well, the only instruction that defendant in this particular case has argued and clarified this in its reply brief. It's saying that the defendant is saying that the aggressor instruction was unsupported. So defendant isn't saying there was sufficient evidence to support an instruction here. Defendant is saying that he should not have been disqualified from the defense of other as for first and second degree murder, and that there wasn't sufficient evidence to support the aggressor instruction. And with regards to the aggressor instruction, you don't look at the evidence in the light most favorable to the defendant. The Supreme Court recently made that clear in its case, State v. Muma. You just look at the evidence and see what the evidence is, and if there's anything to support it, then the aggressor instruction can be given. And even if there's conflicting evidence, it still can be given. So with regards to aggressor instruction, you don't construe it in the light most favorable to the state. But in this particular case, what the state is arguing is there's no prejudicial error because there was overwhelming evidence that defendant did not have this belief. And this is the belief needed to show defense of another. And this is the reason why the court doesn't, another reason why the court doesn't have to wait for the Macklemore opinion to come out to conclude there's no reversible error with regard to not giving the, or saying he was disqualified from the defense of another instruction as to first and second degree murder, because there wasn't evidence, there was overwhelming evidence, and we know from the case State v. Bush that that would render this instruction. I'm sorry, Your Honors. That let me back up. He wasn't entitled to it. The reason the court said he wasn't entitled to it was because he was disqualified from it. But he wasn't. There was overwhelming evidence that he didn't act in defense of another, so therefore there was no prejudice as regard to not getting the.
Let's assume for purposes of argument that maybe someone might not think that the evidence is overwhelming, that he's not acting in defense of another, okay? And that perhaps there could be a reasonable inference that he might have been doing that. Maybe not doing it the best way ever, you know, maybe not perfect, you know, they're drinking, whatever, but let's assume that. So why is he not entitled to a self-defense instruction?
A defense of another instruction.
I'm sorry.
Sorry, Your Honor. Yes, well, this court is, well, first of all, defendant is correct. The issue of whether, regarding what has been called the felony disqualifier, its scope and what it means is before the court in the Macklemore case. But the Crump decision, this court is bound by the Crump decision in re
right.
simple.
Now, there's no evidence in this case before the jury about the plea, right?
You're correct, Your Honor. But in
how do we, where there's no evidence in the case? I mean, I understand that happened, and the agreement was, or the understanding was, it was not going to be presented in evidence in the case. Why does that matter here? Well,
it's the state's contention that it doesn't matter because.
Well, I mean, when I say it, what does it matter? I'm saying the jury doesn't have that evidence. Let's pretend it doesn't exist for the purposes of the jury. Okay.
Well, two things. It wasn't an agreement that not be presented. It was a defendant made a motion in limine that
and obviously perhaps a strategy by the defense attorney, which one might say would be a reasonable strategy for the defense attorney.
Right, but with regards to the felony disqualifier, it was if the court determines that it has to be evidence before the jury, as the state argued in its brief, it's invited by defendant keeping it from the jury.
How is it invited? The defendant's asking for a ruling that is obviously to their benefit, but how would it be error?
Well, it was defendant's motion that it not be put in front of the jury. So if the court, the court should not conclude this, but if the court concludes that it had to be in front of the jury, then it was on defendant because defendant invited that error. And there was some discussion, obviously some discussion of Crump at the charge conference. So the defense attorney here, what he said was he was not aware of Crump. So that was what he said. So Crump had come out at least by the time of the charge conference.
I think the disconnect here is from the defendant's point of view. Is it error to keep that PFF from the jury? Is it error? If it's not error, if it's a sound defense strategy, then how could it be invited error? It's something that the state doesn't like, but is it error?
Well, the defendant would have made a choice.
That's right.
And so far as, if we were judging ineffective assistance of counsel, that issue, we could say, well, that was, a good strategic choice. But if the court concludes that it had to be in front of the jury, and defendant said, no, I didn't want it in front of the jury, how is, it's on defendant. that he didn't want this in front of the jury. And I think the other thing is, if you look at Crump, in Crump, yes, the trial court put felonies in front of the jury for the purpose of the felony disqualifier. However, what was not before the jury was the disqualifier that the court in Crump concluded as a matter of law disqualified defendant, which was possession of a firearm by a felon. So in that particular case, at trial, that particular felony was not put. There were other felonies put before the jury, but that particular.
So you're saying it's a question of law for the court and not a question of fact for the jury?
I think it can be. It is a question of law for the court. Now, there may be like facts. You put it before the jury if there are facts that are needed to be found by it. But so far as to support it, what the court said in Crump was that as a matter of law. Now, in Crump, this was an issue of prejudice. So in Crump, it said as a matter of law. In Crump, the defendant contended and the state conceded that there was an error in the jury instruction. And what the court said in Trump was, well, the jury instruction that was given on self-defense there was gratuitous because as a matter of law, defendant was disqualified from asserting self-defense because he was a felon in possession of a firearm. And that particular felony was not among the felonies put before the jury. And even though there were felonies put before the jury, but the one that the court in Crump said disqualified, the defendant was not put before the jury.
So let me ask you a crazy hypothetical, because I know you love those, all attorneys do, on the possession of firearm by felon and not being able to assert any sort of defense of self-defense or defense of another. So let's say we've got a man with a gun. And he confronts another man and a woman for whatever reason. So the first man who has the gun, he grabs the woman, he holds the gun to her head, he grabs her. Now, the other man who was with the lady, he's a convicted felon. He cannot legally possess a gun, but he does know that there is a gun hidden nearby, and he knows where it is. And let's just assume, for purposes of my hypothetical, he would be in violation of the law. He was, as far as possession of firearm by a felon, based on where this gun is and his knowledge of it and whatever. But the other guy's got the gun to the lady's head. So this guy, the felon, runs to get the gun, comes back. The guy with the gun has still got the gun to the lady's head. He says, "I'm going to shoot her on 3." After he's like 3, 2, and on 1, the felon shoots him to protect the lady who he's about to shoot in the head. So he gets no instruction on defense of others.
If he can, so that's a good hypothetical, Your Honor. It's not so crazy. I can tell you that has come up with regards to some cases, justification for possession of a firearm in other jurisdictions.
Right.
So it's not super crazy. But no, I mean, if he can prove he was justified in possessing that weapon, because the North Carolina Supreme Court has said we do have a justification for possession of a firearm by a felon. So if he can prove he was justified, which is a more stringent test than the defense of other self-defense, then he would not be disqualified, because that felony would drop away and he could assert defense of others.
This case is before jury, this little hypothetical that I just presented to you, and there's no evidence of the fact that he was a convicted felon and he had no reason to possess a gun, we don't have that evidence.
Well, that
and it still doesn't. We say, okay, well, as a matter of law, even though that crime is not here before this jury, and for whatever reason, he wasn't charged, he did a plea, whatever. All they've got is this situation. He doesn't get obviously he just, he doesn't get an instruction on defense of others.
No, Your Honor, that requires some fact finding by the jury to determine whether he was justified in possessing that firearm as a felon. So you would put that in front of a jury.
Doesn't know that he was a felon, or that there was any prohibition on him possessing a firearm, like the jury in this case.
Well, in this case, he pled guilty previously to.
I understand that, but the jury doesn't know that, and it wasn't in this case. before the jury?
Well, your hypothetical is different in that it requires some fact finding, and defendant can in that particular case. Here, the defendant here was not justified in possessing this firearm. He had it prior to the time that he used it.
I understand that. But the crime of possession of firearm by a felon was not something that was before the jury here.
In this particular case, it was not put, you're correct, it was not put before the jury.
So, I mean, as far as they know, he's just a guy, has no, prohibition on possessing a weapon.
In this particular case, they did not know that he was a felon and would have been a felon in possession, that he had pled guilty. You are correct.
Okay.
But in Crump, the same, it was the same. They didn't know. They did put felonies in front of the jury, but it wasn't the one the court in Crump said would disqualify him, and therefore he wasn't entitled to self-defense in the first place. So, it's Crump, this court is bound by Crump, and it's not distinguishable in the way that defendant argues that it is. But again, it's the state's position that you don't need to wait for McLemore because you can conclude here that there was no reversible error in the jury instructions because of the overwhelming evidence that defendant didn't act in defense of another. I just want to mention a couple of more things about the felony disqualifier. Defendant has raised a constitutional issue with regards to that, raised it in its principal brief in a one line, and that's improper under Appellant Rule 28B6. It comes back in the reply brief and gives a little bit more that that's insufficient. With regards to the constitutional issue, facially unconstitutional, defendant has to say that it's unconstitutional in every situation. And also, yes, the North Carolina Supreme Court has said that self-defense, defensive force, defense of others, it's an inherent right, first law of nature, but it's also made it clear that it can be subordinate to the rule of law. So, for example, the self-defense, defensive force, a big principle of defensive force is being at fault. And so being at fault, aggressor is the classic at fault. Well, aggressor, if you will, disqualifies someone from doing defensive force. And so in that particular case, the use of defensive force, the justification is subordinate to the rule of law. If, for example, the defendant does not notice the state that it will present a defensive force defense prior to trial, he can be disqualified completely and can be prevented from putting on a self-defense or a defensive force defense, assuming the judge makes the proper findings of fact and goes through all of that as like a discovery violation. So that it is a inherent right doesn't mean it's not subordinate to a rule of law. And here, this felony disqualifier, even though it's not provided for in North Carolina case law, it does grow out of the principle that if someone is at fault, they cannot assert a defensive force defense. And it in itself is not unqualified. A lot of other states have ones that say you're disqualified because you commit a crime or because you've done something unlawful. Here, it's specifically a felony. Crump found that it does have a temporal nexus, and common law defenses do survive. So, like in this particular case, he can still assert imperfect defense of others. With regards to 51.2, people can still assert common law defense of habitation, and there may be other things that are out there. I wanted to speak specifically with the time I have left about about the common law. If you look at this, and the common law does exist to the extent that it still exists and hasn't been covered by the statute, it does exist. And the statute, the common law should be read to supplement the statute, but only to a point and only in some regards, because if you look at 14-51.3A1, it is exactly like our common law. It has adopted, codified the basic principles of our common law for self-defense. Now, what has been cited as a difference is not a difference. What has been cited as a difference is the concept of a no duty to retreat. But if you look at North Carolina common law, we have had a no duty to retreat, stand your ground for about a century and a half, from what I can discern from our cases. So that is not a difference. And so to say, for a defendant to say, as this defendant here said, well, I'm asserting common law self-defense rather than statutory self-defense, they're now all the same so far as that there might be something different with defense of home and habitation, but they're the same under the statute as under the common law because it is the same. And certainly the legislature would not have intended for someone just to be able to get out of this being disqualified by asserting, well, when these two are the exact same, by asserting, I'm asserting common law self-defense and nothing under the statute. So that would be sort of a ridiculous thing. And finally, defendant filed a memorandum of additional authority, a little vague, but it seems to be the defendant is, via the memorandum of additional authority, accusing the state of taking inconsistent positions, and me in particular, because I was the attorney in the cases that the defendant cited. In this particular case, the oral argument in Crump, and another case, Leaks. But if you look at all of those cases, if you go look at the briefs and not just the oral argument in the briefs, the state has in those particular cases consistently said that this particular part of the statute, 0.3A1, is the same as the common law. And so for that reason, even though defendant said here, I'm asserting common law defense of another, that he is still disqualified by 51.4(1). And if there are no other questions, again, there was sufficient evidence to support defendant's second-degree murder conviction, and there was no reversible error in the jury instructions, and the state would ask that you affirm. Thank you.
Rebuttal?
Okay, can you hear me?
Yes.
Thank you. First of all, of course, Mr. Williams was entitled to a defense of others instruction, and he didn't get a complete and accurate instruction. I don't really want to spend more time on that, unless you're going to go into the disqualifier portion, which I think the Supreme Court is going to solve for us. So I'd like to go back to the facts again. I want to have you think about those 8 seconds of pause from Sierra's perspective, right? She is laying in the back of the car. She's got knots on her head and the side of her face from this vicious beating. Michael has said, I'm going to kill you, bitch. Michael has attacked and attacked and attacked. He stood up for 8 seconds. From her perspective, does she have the right to still defend herself? She's laying in the back seat of the car, basically helpless, and he's standing right in front of the car door. There is no case that would suggest in the domestic violence, assault, murder context that that is a withdrawal. He stopped to catch his breath. He did not indicate by any means that he was going to stop assaulting her. In fact, what he said was, Tyler, get your woman off me. I can do anything I want to her. I cannot accept the proposition that that constitutes a withdrawal. It just doesn't. I would also ask you to look back at the video and just watch Dominique Williams. So there's about 1.5 minutes from when the car pulls over. For the first 45 seconds, everybody's on the far side of the car, so you can't really see what's going on. But we have the testimony that tells you what's going on, which is that Sierra's in the back of the car and Michael's standing over her, beating her, and the other two are talking to him, trying to hold him back pulling his hair out, trying to convince him to stop. And Dominique, while you can't see what anyone's doing, it's clear he's engaged in that. He's not standing off to the side. You can't see him, and he's down there, and you see sort of arms and heads popping up. And then it appears to be the moment when Michael stands up and pushes Tyler, because there's sort of a sudden movement. And after that, Dominique walks away, and you can see he's breathing hard. His breath is coming out. He's got his hands up behind his head. He looks completely exasperated. Like Judge Dietz says, what am I going to do here? Like, he won't stop. And then he stands still for 20 seconds, and then you can see him sort of reaching, and I think probably his gun was in his waistband, and you can't see what's happening, but he's making the decision at that point. At some point he had to decide, I'm going to shoot Michael. And that was, occurred in 20 seconds of a very stressful situation. And I think that has to be taken into context. I think the video, if you watch it under that, under the understanding of what the witnesses testified to, and they're the only eyewitnesses, and they were consistent. Michael started the beating. Michael didn't stop. They were trying to stop him. I mean, if you didn't have any testimony and you just watched the video, you wouldn't be able to really understand anything about it. And that's why you have to take the state's evidence that they put on together with the video. And when you do that, there's no withdrawal. And there's only one reason that Dominique would have shot his best friend, Michael. There was one other fact I wanted to point out that we didn't mention earlier, and that was Sierra's testimony that the week prior, they had been at a party, and there Michael was also assaulting her, and Dominique was trying to hold him back, and Michael pulled out a gun and pointed it at Dominique, and then somehow that sort of stopped everyone. So there's not positive evidence that Michael did have a gun on this night. The witnesses were asked, did you see him with a gun? And they said no. But from Sierra's point of view and from Dominique Williams' point of view, it's certainly a possibility that Michael had a gun on him, and that he was willing to pull it in order to stop Dominique from stopping Michael from beating Sierra. And I think that's another factor that leads to the very same conclusion, that there's only one set of broad facts that are happening here. He was beating her. He wasn't going to stop. Dominique didn't know what to do except shoot him, and that's what he did. If there are no other questions, Mr. Williams asked this court to vacate his murder conviction, or in the alternative, to order a new trial with accurate instructions on the defense of another. Thank you.
All right. Well, thank you very much for your arguments. And this will conclude our session of court.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you all.
Thank you.